Hello everyone, welcome back to the Catch Up Court TV. Gosh, we do nothing but catch up with legal cases over here, and we talk nothing but legal cases, and we are going back to the current retrial because that verdict has caused, I'm not going to call it World War III, but it's there. I would say it's up there. There's so much to discuss. The police department has released messages. Jurors have come out to discuss this case, and new conspiracy theories has been spawned. So here to talk about it with me is Andrea Burkhardt, who has been covering this case gavel to gavel from trial one to, and the second trial. She has a lot of insight that I really want to pick her brain from. You know, she has been a criminal defense attorney for, I believe, 20 to 30 odd years, very experienced. I want to pick her brain. I want to go through every part of this trial and talk about it. So Andrea, thank you so much for joining me. How are you doing today?
Oh, Doc, I'm awesome. It's a pleasure. It's good to be back. It's been a minute, hasn't it?
Yeah. It has been. I have enjoyed your coverage. I love the way that you keep exposing how Judge Bev has been running the courtroom. I love how you've been exposing how the police department works and you know the failings there. Tell me, have you seen any of the jurors coming forward and all those things? Have you seen that?
I have. That, like you said, there has been a flurry of stuff to keep up with, and so I can't promise that I've seen everything, but I have done my best to at least stay on top of some of the main developments. You know what this reminds me so much of, Hines? You'll remember back during Depp versus Heard, okay? Back when we were watching the Johnny Depp trial, and I remember having a little bit of a sinking pit in my feeling when I realized there was a kind of widespread expectation that we were going to get a verdict and then things were going to be over. It was going to be settled. It was going to be definitive. Like, that's the whole purpose of doing it. And I knew even back then, like this is unlikely. Just given human nature, given the personalities that we're dealing with, given denial and how it works. Like it was just not going to happen. And unfortunately, you know, there was some breathing room for some of that battle to continue. With Karen Reed's case, we're seeing so much of the same kind of phenomenon, right? Like, it should be over, it should be definitive, but it's not. You got some people that are absolutely never going to take no for an answer. They're going to continue to insist that we believe their completely unbelievable version of events here, that we just should be emotionally manipulated into gaslighting ourselves and ignoring the fact that John has not a single injury on his body consistent with being hit by a car. He's clearly a guy who's beat up and hucked out onto the snow and left to die. So, you know, this is just an unfortunate part of the justice system. The fact that the justice you actually get out of it is quite imperfect at best.
Like a lot of the takes on here, I didn't anticipate it because, well, I mean, I didn't think it would be this bad. I didn't think people would be making arguments of jury nullification
Mhm.
and people will be saying that there were plans in the jury, and I'm like, like, before going into the substance of the case, like how likely is it that you can plant someone in the jury?
Mhm.
This isn't the first time I've heard this, by the way. But
Yeah.
how likely is that? Is that likely at all? Is that even possible?
Well, I mean, I'm not prepared to say it's impossible, but it's going to be real difficult. And the problem is, okay, you planted one person. What are you going to do about the other 11? Like you're kind of taking it on faith that those other 11 are going to just fold. And I remember back when we were worried about like Elon buying off the jury and stuff like that. It was the same, similar kind of dynamic. Like you can't say it's impossible. It certainly
Yeah.
happened. It's mob cases. It's kind of notorious for things like that. And of course, we've got a retired, a former mob lawyer here on one side of this case who apparently didn't really learn enough about that representation to even like figure that maybe you should plant the jury. Like maybe that's a thing a mob lawyer would do. He didn't even do that. I wonder if Morrissey is regretting that he didn't get his money's worth.
Oh gosh. Yeah, so I always look at this trial when I assess this trial. Yeah, I always want to think. I always want to try and understand where everyone's coming from, right? Like
Hmm, hmm.
I want to see what everyone's trying to say. And I've heard takes like, that this is like Casey, like Karen Reed got away with it, like Casey Anthony,
Hmm.
like OJ Simpson got away with it. Do you think that this is comparable to any of those situations? Like,
No, it's the only way this is comparable to OJ is that, had they not gotten greedy and had to go and try to improve their case, they might have been able to get something. With OJ, there was a whole issue with the blood evidence that they found is extremely incriminating. But as it turns out, the blood had anticoagulant in it. They were able to tell that like you got blood drops out here at the scene that you got out of a vial somewhere. Like somebody did that on purpose, and we had similar kinds of issues in this case with the bumper sprinkles and stuff like that, the glass that was never able to be matched up to anything at the scene. uh but just in terms of like, is this an outcome of somebody that got away with it? Like to me there's very little credible way to be able to look at this trial and come out with that as a good faith take. To me, that's just a refusal to see the writing on the wall and acknowledge reality. It is so hard to get a unanimous jury verdict on anything at all. Like to get 12 people to agree on anything at all, particularly in this day and age. This is a very divisive era that we live in. It requires enormous consensus, overwhelming, commonality of perspective. And so to just kind of want to throw that away as jury nullification to me is just an utter failure to internalize the real lesson of this trial, which is that there is a point where people will no longer be gaslit. They will
yeah,
see what they see with their own eyes, and not be talked out of it.
yeah, and something I've noticed, in this trial has been the contrast by of people watching it and like having their own view of the evidence, and then you see someone saying something that like for example, Jordan, I saw a take in regards to the x-rays that was introduced because of Welcher, and they
Hmm.
were saying that the x-rays were fake. It wasn't the real x-rays of John O Keefe,
Yeah.
because Welcher said that he had some fractures on it, so the x-rays must have been fake, things like that.
Hmm.
Like, but so like, I want to ask this, that because of this all this jury talk, but like, they call them stupid, etc.
Hmm.
Which is a better system, jury trials or bench trials? Like, which one is actually better for trying criminals and getting a fair conviction?
Yeah, well, it's very much a case by case thing, because it can certainly depend on the judge that you get and the jury that you get. But the bottom line, from my perspective, I'm a criminal defense lawyer. I'm used to having to make this type of decision, and we call a bench trial a slow guilty plea, and we call it that for a reason because, I mean, number one, you just have you tend to have incentives with judges where being quote unquote soft on crime is not really it's not really going to advance your career. It's not really a favorable position to be in. So very very common for judges to just default in favor of the prosecution. It's easy, just believe the cops and don't ask too many questions about stuff. Don't rock the boat. But also just the basic structural issue of do I want the Commonwealth to have to convince one person, or do I want the Commonwealth to have to convince 12? I would much rather would much rather, generally speaking, that the Commonwealth have to convince 12 people. So even though it's far from a perfect system, the jury system, doesn't always get it right. But I think generally the jury system, jurors do make a sincere effort to do what they think is right in the situation, and they can only do the best they can with what they're given in the case to work with. Uh, so even given those limitations, I'm generally going to prefer, in 99.9% of the cases, I think a jury trial is going to be the better choice.
Yeah, I mean, like we have seen cases like Zachary Anderson where they get it wrong,
Mhm.
like in my
Mhm.
opinion, and that
Yeah.
was, like, so it's not like it's, yeah,
Mhm.
as you said, it's not like it's perfect, but
Mhm.
when I see a lot of the outrage today, I'm like, what do you guys want? Like, did you guys want her to be in front of the judge only and have the judge decide? Like, wait, if
Mhm.
Bev was actually over this, if Bev had to decide this, how do you think she would have decided this
Yeah,
case if
exactly.
it was a bench trial?
Exactly. Yeah,
Yeah.
no, no, 100%. I mean, that's all you gotta do is just your thought experiment. Give the decision to Bev, and what do you think is gonna happen?
I'll allow it.
You know? Do you think she's going to have any doubt about any of these investigative steps or anything like that? Is she going to? She wasn't even curious enough to ask questions about the Sallyport video, and why was she getting like 10 different stories from the prosecuting attorney's office about where the video was and why it hadn't been produced before and things like that. She didn't care about that at all. So I can't see her questioning the Commonwealth's theory too deeply.
Yeah, like I always look at this trial as like it's like this. I don't know how much sense this analogy is gonna make, but I look at this trial as a prosecution trying to bring let's say a case of a shooting, right? They have the
Hmm.
bullets, they have the casings, they have
Hmm.
all of those things, they have the gun, and they point it all back to Karen. Let's say that Karen was accused of shooting him that night. They have
Hmm.
all
Hmm.
that all pointed back to Karen, but the autopsy comes back. There's no bullet wounds
Yeah.
on. There's no, like
Yeah.
like that's.
Yeah.
I'm like,
Yeah.
when you look at it,
In
like
fact, he has freezer burn.
I gotta like every time I look at it like that, I'm like, there is no
Mhm.
way you can say, yeah, okay, fine, the evidence is
Yeah.
there. Like because
Yeah.
I understood what Dr. Rentschler was talking about. Like, yeah, all those things could be there, but
Mhm.
there is no way to put the cart before the horse. Like, so like, yeah, it's not perfect, but like anyway, but the main point I wanted to ask, what I wanted to ask was, has there been any case, have you tried any case or seen any case where the medical examiner will come in and say this was a, well, where the prosecution, sorry, is saying that this was a
Mhm.
homicide, and the medical examiner is saying uh can't rule it as a homicide, can't even determine that. Have you ever seen a case like that?
I have never seen a homicide prosecution like that, ever. I can't think of an example. It probably has happened before, but it certainly isn't gonna be common. I'll tell you the closest thing I can think of is a situation that we had many years ago, over in Walla Walla when I was in private practice there. There was a shooting. It was a country store, this place was called. It's like a, kind of Western Ranch Goods Emporium on the edge of town. It's kind of a creepy little place, like one of those places that's like up to the rafters and like different boxes and things like that. But just a long old school establishment. So somebody broke in late in the evening and was going to burglarize the store, or like early morning, 2 a.m. or something like that. Well, didn't realize apparently that the owner actually sleeps there in the store. And so the owner woke up. There was some kind of a confrontation. The burglar fled out through the front door, and was running away across the street, getting away about 100 feet away, when the shop owner shot the person in the back with a shotgun several times, and killed him. And so that was a question where, I mean, there were serious questions about, is this self-defense? Is this, beyond the scope of what a self-defense situation would allow? And so what they did in that case is they did a coroner's inquest, and that's the process that we have in Washington when a medical examiner is like, look, I'm not sure. I can't make that final determination myself. There are decisions that are not medical decisions that go into whether this is going to be a homicide, whether this is going to be a defensive or something like that. So, I mean, the system we had, that's what it was made to do, was to be able to have the coroner's question answered before the prosecutor makes a decision. And, well, am I going to go forward and prosecute anybody in this situation or not?
How did that case end up, by the way? Just out of curiosity, how did that?
There's a jury. It's a jury trial to a coroner's inquest. They decided it was self-defense. He didn't get prosecuted.
So he must have got away with it like OJ.
I'll let you guess the colors of the people involved.
Oh, okay. Fair enough. The interview with Bob Alessi and Yanetti. I stayed up all night. I couldn't sleep. I mean, I haven't slept a ton throughout this case. I'm just watching everyone's take from and you know how late it is here in the UK. But
yes,
that interview kept me up to like 5 a.m. in the morning. And basically, and there was something that came out of it that was very interesting to me. But before I ask the question, did you see the interview where the McCabe's Albert? I want to get it right because I don't want to be gaslit into Colin I don't know, the Alberts came out and all of those people came out and basically said it would be a crazy idea for a conspiracy theory like this to come out. Did you see that interview? What did you make of the interview? Sorry.
Heinz, it sounds like just about every interview I've ever had with a guilty person where they insist there's no evidence, and they insist like I would never even do that. Like that's not even possible. I've heard this story a million times, Heinz, and it's just not credible. They don't have good explanations for their own conduct. And unfortunately, it's one of those situations where I don't know if they were covering up the death of John O Keefe. I don't know if there was some other shady something that they were covering up that they didn't, reason why they didn't want police looking closely or something like that. But the bottom line here is that it's really their own conduct that has made them look so suspicious. It's nothing that anybody's had to make up or like, if people had just thrown accusations out there, I think they'd have a lot of sympathy because if it's clearly unfounded, people would understand and appreciate that. But it's the fact that it's their own behavior and their own sketchy, self-serving, just acting like we're stupid kinds of explanations. That's the reason why they're under so much suspicion.
And to go back to my question, like, because they said that they were not allowed to present the alternative theory to what the prosecution had for them. So, I'm guessing they wanted to show how it was possible that there was a cover up, and they wanted to show the possible real killers that the investigators should have gone to. Is this normal in courts? Does the judge normally strike out and not allow alternate theories to be served up by the defense?
No, not at all. I mean, other than the Richard Allen trial over there in Delphi, Indiana last year that I was there for, that's probably the worst situation of a defendant being completely deprived of the ability to put on any kind of defense to the charge that I have ever seen.
Oh
But
wow.
this is a very close second. This particular case. Uh, they have the medical examiner on the stand, for heaven's sakes, and the defense isn't allowed to ask if his arm is dog bit and if he was hit by a car. Like, this is the medical freaking examiner, and that is the Commonwealth's case. How can you not be allowed to ask those questions? But that was just one more example of the thumb that was placed on the scale. That's what's so impressive about the win to me. I think it was Alan Jackson said it in he did an interview with Howie Carr. I think it was him that said, maybe it was Mr. Yanetti or Mr. Alessi in Ian's interview, but somebody said this victory, it was not because of the process, it was in spite of it. Like, this was
Mm,
an uphill battle, and that's part of what does make it so impressive to me, because yeah, I see that 1,000,000%. I see how the judge was doing everything in her power to restrict them, to tie their hands behind their back, to make it as difficult as possible. And their ability to overcome that is it's really admirable, because it takes a toll on you. Dealing with a challenge like that at trial, dealing with that kind of unfairness at trial,
right.
it's not a fun place to be.
Right. And also, have you heard of Judge Jack Lew? Have you heard of him?
Hmm. Yeah,
Um,
I've seen Jackie Lou. I've seen Jackie Lou around. Heinz, I got to tell you, I'm personally I'm concerned about the man. He doesn't seem to me to be in necessarily his best health. But it does kind of look to me like we can have another dissection of the mainstream media and their takes and their complicity and so forth in this case. I think he's a good example of that. They're perfectly willing to exploit what appears to me to be a man who may be in a little bit of a vulnerable condition, if that gets him the soundbite they're looking for, and it's pretty appalling.
yeah, like I'm just gonna quickly play that for people that may not have seen it, because I wanna
Hmm.
I have a couple of questions to ask you in regards to the comments he made. So
Hmm.
this is the interview that he did with CBS
Being held
Boston.
responsible for the death of John O Keefe.
And Judge, outside of court, one of our attorneys was asked, are you calling for a reinvestigation into what really happened? You think the Commonwealth will actually reopen any type of investigation?
You know, I don't have any inside information, and I had no communications with the folks involved in this, but certainly not. Karen Reed killed Mr. O'Keefe. They just couldn't prove it to a jury. And in America, that means you're not guilty. It does not, I repeat, it does not mean that you are innocent. She had a lot of nerve saying to that microphone that I want justice for Mr. O'Keefe. She was acquitted, but there's nobody else to investigate. There's no third-party culprit.
Oh my god. Oh my, I still couldn't believe it. I still couldn't believe it. Like
Hmm.
when people say that just because they're not guilty, then they're not innocent. What does that really mean? Like, does that have any legs? Are people are people ever considered innocent after they've been proven not guilty? Like,
Un Under this standard, there's really no such thing as an innocent person, because nobody could ever be innocent. There's no innocent option on the jury verdict form. All we ever have is guilty or not guilty. So by this standard, nobody is ever going to be innocent once they're accused. That power of the accusation is enough to transform you into a forever not innocent person. That's what I find so horrifying about these comments, and so particularly disgraceful coming from a member of the
hmm,
bench.
that's what
uh,
disturbed me. Yeah, that's what disturbed me. Yeah.
because the taint of the accusation, I mean, let us we need look no further once again than Depp v. Heard, Heinz. It's the case that covered everything. It touches all cases and all things. And he told us straight from the witness chair, as soon as the accusation was made, his life as he knew it was over. It's never the same again. And that's simply the reality. There are always going to be people out there who think that Karen Reed is guilty by virtue of nothing else and simply the fact that she was accused of it. And so it's unfortunate to see the process that we have to adjudicate those kinds of disputes. It is resolved. It is at the end. There is no further process. It's not a situation where like, well, maybe we'll have an appeal and there will be a new process or a new trial or something like that. This is over. It's done. And it's sad to see that that lack of willingness to internalize why the jury made the decision that they did. Like, not just understand, yes, okay, we can look at the verdict form and read it. We understand the words not guilty. But why would they reach that conclusion? And at least some of the jurors that have spoken so far have made it very clear, well, because they are not at all convinced there was a collision here.
Right. And we've heard a lot of jurors come out and speak about their thought process, and they, to me anyway, they seem to have taken this case completely seriously. People forget that they were in that deliberation room for 4 days, 21 hours if you want to go down the microseconds of the whole trial. So they were in that, so it's just strange. It's just strange to me how people think that people cannot reach a verdict that is different to how they view it. You know what I mean? Like, so do you think that they will ever open the investigation again? Do you think that will actually happen?
No, absolutely not. No way.
You think they should?
No way. Of course. But no, they won't. There's just no chance. The politics of this situation are very clear. We saw from the police union issued a statement. They're doubling down on nothing to see here, no problem here. You got Proctor out doing his little PR tour as well. Like, there's no learning here. There's been no internalizing. There's been no reflection. There's been nothing like that. Just continued denial and deflection and blaming. What we're seeing is very much akin to an abuse type of dynamic with how the public is being treated by their superiors in the law enforcement, the powers that be that get to wield the levers of that criminal justice system and use its power against the citizens. They aren't looking to be told how to do that. That's been the big takeaway from this case. And the thing I was most interested to see, I didn't have a lot of optimism, like what's going to happen in the aftermath of an acquittal. Is there going to be any type of insight? And it appears that may be too much to ask.
All right. Do you think that this case should have been tried as manslaughter? Do you think they even had a shot there? I mean, I know it's not the same prison time, and there's not a lot.
Sure.
But do you think that they had a shot there if they just brought manslaughter and not second-degree murder? Because I'm trying to compare it to the the lady that killed a child. I forgot her name. The lady that killed her child. She was facing a death penalty. And one of the jurors came out to say if she was facing a just life in prison, they would have convicted her because, but the death penalty, Casey Anthony, that's it.
Casey,
yeah, that's it. So do you think that if they did bring, just forget murder and just bring manslaughter, do you think the prosecution would have had a shot at winning it?
I mean, it's possible. It would have been a very different case. And I think the overshooting definitely doesn't help because, you got the prosecuting attorney up there having to try to defend it and advocate for it and make up reasons for why we should believe that that's what happened. And if those reasons lack credibility, then the attorney has lost credibility. And if the attorney has lost credibility on one charge, it's kind of hard to go ahead and think that they must be acting in good faith in the others. I think in this particular trial too, on the adjustment that the defense made to really focus on there was no collision. It was such a good one for so many reasons, but a big one, of course, being it negates all the charges. If you buy that, then it doesn't matter if we're talking murder, doesn't matter if we're talking about hit and run, doesn't matter if we're talking about manslaughter. There was no collision, so she did not cause John's death. But we saw in the first trial that just the way that the jury approached the situation there was very different, and they were looking at it more as like a, let's solve the problem, let's solve the case, let's come up with the answers that we haven't been given by either side. Let's try to sort it all out for ourselves. They had a lot more information in terms of like the third party culprit witnesses who had been called to testify and stuff like that. And that jury apparently was a little bit more inclined to maybe lean in the direction of a manslaughter charge. So I think there's a lot of different things that go into that question. Like just there's so many variables with how the trial can go and stuff like that. I think in this particular trial, the one we just watched, it wouldn't have mattered because they did such a good job with there was no collision, that I think that stuck. But if this jury had the same case presented as the first jury and in the same sort of, do you believe the defense or do you believe the prosecution kind of binary choice, then I think that's the situation where you end up with a much greater potential for a compromise verdict, that they could have just thrown up their hands and been like, well, don't think it's murder, don't think it's nothing, so we'll just settle in the middle on manslaughter.
Right. Also, I do you, just putting it out there, do you think that do you think that they even had a case at all? Like, no, because I asked because I've seen family friends, John, I forget his name, Jack Jackson or something like that, a friend of John O Keefe. He came out and done an interview with Court TV. He basically highlighted and said that the evidence was right there, and they, and on Court TV they highlighted taillight pieces, the microscopic pieces in the shirt. John's phone activity suddenly stopped working at 12:33. The battery temperature, they highlight all of that. Like, it's like, could they have gotten a guilty verdict? I like, just based on that. Forget the body. Just based on that. Like, do you think a jury would have just? I mean, we know the answer now, but like,
Yeah.
but any other jury, would they have said?
Well, I'll give you what may not be a popular answer, which is that this is very much a winnable case for the Commonwealth. Okay, when you consider what the prosecution has, what they're working with, when they walk into that room, they're working with a defendant who thought that she did it, and made at least some kinds of statements to that effect, that she thought maybe it was possible. You have the broken tail light. You have some pieces that they have recovered from the grass. You have nobody has seen this guy since he was leaving the waterfall and getting into Karen's car. Nobody's reporting seeing them. Hines, these are very good facts for prosecution to be able to work with.
Yeah.
I think the challenge here is that the case always kind of falls apart once you start to put it under more close scrutiny. They can win it from like the 10,000-foot level, and if that's all the jury is interested in looking at, then I think they could potentially get a verdict. But if you do start drilling down into the details of like, well, but this taillight plastic, there's no chain of custody for any of it. The way that you've reported that you found it is just very bizarre. Like, there's a little 1 square foot of plastic on the street, but then there's a ton of plastic all over the yard, and then you found everything to reconstruct this tail light, like none that was in the road that the plow might have carried away, that you were never able to recover. But at the same time, you also recovered a lot of plastic that did not fit into that tail light. Okay, the final count after Ashley Vallier testified was, she said 23 pieces went into the reconstructed taillight. Well, what did they collect from that yard? Was it 47 pieces of taillight plastic? So where'd the other 24 pieces of plastic come from? It's just once you start looking at it, more closely. And of course, I mean, obviously the injuries have always been, that's always been the limitation on the Commonwealth's case, is the fact that John's body does tell the tale, and it doesn't pass the eye test when it comes to a car collision. So that was kind of always going to be the challenge. Like, is the jury interested in the questions? If they are, that does not favor the Commonwealth. But if they were willing to just like take a knee jerk, yep, sounds easy. Like, this is a mental shortcut I can take to get to guilty, and that's all I'm really interested in doing, then I think it would have been possible.
Right. And that's why I really love how the defense on this trial anyway, they really drilled into the accident. I saw lawyers say no, the defense. I saw Twitter law graduates say say that the defense should have not put on a defense at all. That they should just pack down and go home because they've just proven a collision. They've just proven that a tail light can brake at 24 miles per hour. And not and for me, I was sitting there listening to them. I was like, do you not realize that all those texting came with the sucker punch of a medical of a medical proposition that if you did have someone that was hitchhiking, that was hitching on the street, begging for Karen to stop for him, and Karen just when driving and just and he didn't want to move. That there were so many things in that test that it makes it no sense how anyone would buy this story. That's why I thought, like they just that Arca done, at least the defense on this occasion, they done a really good job in going straight to what the Commonwealth were trying to tell the jury. It's like, okay, cool. If you want to go to the collision, let's go to the collision. Let's go there. Let's stay there.
Yeah.
And do you think that was a good strategy this time around, and not follow and not stick around for the cover up, like because a lot of people say that they abandoned that, and just what do you think?
Yeah, I think it was really smart because I think the advantage that you always have as the defense in a criminal trial is that if you can get the jury to be asking questions about stuff, that benefits you because every question the jury has is a potential doubt, and especially if the Commonwealth isn't able to answer those questions, that's a potential doubt that you had. So you can kind of shoot yourself in the foot sometimes if you've got a good like counter theory of what happened. It's just you got to be very careful in pursuing it because you run the risk that you're trying to persuade the jury of things that it may already occur to them to be asking about it, but then as soon as you try to persuade them, it just becomes a question of, well, do I believe you or not believe you? And you end up kind of implicitly taking on this burden of proof that you don't have in a criminal trial. You never have as the defense. And so this time, I think it was just so much better because they didn't have to make any kind of affirmative representations about who did what, about what exactly even what happened, where it happened, what time it happened. None of that. It was left for the jury to imagine for themselves ways that some of these things could have unfolded, and all they needed to simply show was that it was possible. Like, you can't rule it out based on the investigation that was done, and for some of it, at least, it's unforgivable that they can't rule it out. There's absolutely no reason why they should not have been able to rule out planting that tail light, because all you had to do was just properly document, secure the scene, document everything, maintain your chain of custody, and you would have had this thing locked down. That was always their strongest piece of evidence, was those little 3 pieces of tail light plastic that the CERT team found at 5:45, they say, out there at 34 Fairview. So the fact that they didn't lock that down and take those questions off the table, it's 100% lies at their feet.
Right. Right. And I want to ask a question. I want to ask a question about Techstream data. I don't know. Like, have you ever done a case with Techstream data, by the way? Before I go into my series of questions, have you ever done a case like that?
So not with this kind of data, and definitely not with infotainment data, but it's not uncommon at all to see black box type of data come up in motor vehicle homicide types of situations. I had a couple, just like ironically in the last couple of years, I had a couple of cases involving motor vehicle homicides where data came in. So it's kind of something I'm used to seeing. In those cases, there was no dispute over whether there was an accident at all. I mean, I think that is kind of the the weird thing, the thing that like you're not normally used to seeing. Like, why are we pulling the vehicle data to see if there's an accident? Like, look at the car. Like, look at the car. You can kind of eye test thing again, guys. You know, like just eye test. Kind of tells you what you need
Look
here.
at the car. Look at the autopsy. Look at the car. Look at but yeah,
that
like,
was what was so just strange about the data and how they presented it was it just, you know, to me, my read was it was such a reach. Everybody had to acknowledge that, well, the trigger events aren't a collision. Doesn't necessarily have anything to do with the collision. And in fact, like the thing that kept bothering me was how you have the exact same trigger event happening within 10 minutes of each other on the 29th. And one of them you're saying is Karen Reed backing up at, you know, 80 feet at 20 some miles an hour and hitting John and sending him, you know, careening across the property. And the other is a perfectly normal, unremarkable 3-point turn. And I just have a hard time like reconciling, you know, what's your explanation then for why these things are triggering, and why would it trigger for this collision that you're positing exactly the same as just turning into a driveway and getting yourself
yeah,
reoriented back towards Fairview.
yeah,
Like there's something there that is missing is the explanation. And to me, a big piece of the data, it's always looked like, well, this is
it's contextless.
winter conditions. You've got your cat's track of snow. It's just starting to get very slippery at this point in time when you're out on the road. It makes perfect sense to me that the wheels are spinning in the car, and that if the car is sending out codes, so to speak, that it's likely related to stuff like that. But there was never any kind of attempt to unify that from the Commonwealth. Maybe that was, you know, a concern that I and only I had, but it was just one of those things from the data that made it extremely difficult for me to take the accident argument seriously when you don't have black box data and you're trying to use this diagnostic type of data, but you don't have an explanation for what's causing these error codes to trigger in the first place.
I don't even know how they even arrived at the time and date that they even did, because I mean, I'm not sure if the defense drilled into this, because I was watching the different keys, the different key cycle. Was it 1162 key cycle or whatever it was? And I was looking at it and I was like, wait, where's the time and date? And apparently they do the whole syncing of the clocks together. And I was hoping defense, would you ask the question, how did you ascertain the time and date for this? Like, I'm not sure if I heard it. Did you hear it? Did you hear that question ever asked by the defense?
It was really not clearly articulated how they could tell. It was very complicated, and that was definitely a failing, I think, on the Commonwealth's part to not explain it. Now, is that because there's difficulty explaining some things? And I'm telling you, Heinz, I am quite suspicious of this SD card that just like appeared on the board that everybody missed, and apparently Guarino missed it, Gaffney missed it. Nobody, like I, a lay person, know what an SD card looks like. Like this is not like a tiny thing that you just overlooked. I for one am extremely suspicious of this mystery SD card. But even that aside, the best explanation that we got was just, well, you have the key cycle that doesn't have an on off, or doesn't have a timestamp, a time or a date stamp, but you do have the times associated with the infotainment system. And when the infotainment system is powered on, and then you have that running clock. And they were clearly trying to show, well, if we just match the infotainment to the key cycle, then we can figure out the time frame. But they never answered the question, how did you match the infotainment system to the key cycle? Was this just the one that fit for you, or you know, how exactly did that process take place? And I thought it was fascinating too when we had that we had one of the motions that Mr. Alessi had brought, where he re-raised, like, everybody knows the key cycles have been at issue. That's been the case since the first trial with Trooper Paul and his count of the key cycles, right? And there was no way that you could get this one to correspond with the 34 Fairview, because the car had to have been turned on and off more times then get you to that key cycle. So I was a little bit surprised to not see that a little bit further developed, because I think that might have maybe answered some of these questions about how are you trying to do that. I don't know. But clearly the defense ultimately decided it wasn't necessary to do that. They had done enough to prove that there was no collision. But I remain, yeah, I'd like to know. I have questions.
Yeah, and it's very interesting that with Triple Paul, his theory, I can't even remember, was it 12:45 that the collision happened, or was it 12:34? Whatever.
Well, they had to change mid-trial. Remember, they had to change in the middle of trial. Like, they started off at opening with it being 12:45 because it had to be, because that's what Jen McCabe said based on her story of texting John, and that each time she was looking out the front door and seeing the SUV there. And then the very last time, she sees the SUV drive away, and that's at 12:45. Of course, the problem is we since learned Karen's Wi-Fi has connected over at John's house at 12:36. So the SUV is not, in fact, sitting out there in front of 34 Fairview when Jen McCabe says that it was. So they had to shift the timeline. Like in the first trial, it was never really coherent anyway. It's always been a mess trying to make the data fit something that didn't happen.
Yeah, like, and I wish Bev allowed Triple Paul to come in, or at least like the defense called Triple Paul in. Like, do you think that they should have called Triple Paul in? Because I personally thought that would have been a good idea. Bring him in and be like, hey, you testified in the first trial that it was at this time, at this time, at this time. Were you wrong? I don't know.
Yeah.
Do you think that was a good move? Sorry.
I think that's true. It's a good point. It is something that I think the defense, you never really know with Judge Bev what she was going to allow or not allow. That was part of the challenge of this trial, is like, well, okay, in a normal courtroom, yes, of course you could do this. You'd be able to bring up the prosecution's witness from the first trial. You'd be able to point out that person's theory and just the fact that they now seemingly are unsatisfied with that. Poor Trooper Paul, they made him write a supplemental report and then ditched him after trial and hired these jokers over at Aperture. I almost felt bad for him after that. Like, you couldn't even just do it. You made him write a supplemental report, and then you're like, he can't pull this off for us. We gotta go get these jokers. So I mean, like, in a normal courtroom, it should have been an option, but you just never know in Judge Bev's courtroom whether she was going to allow them to open that door or not.
Kangaroo court. That's called, yeah. I find it gone.
I just, I would love to be more generous, to Judge Bev and to the process that she oversaw. But it really was just disgraceful. It really was. It made the whole Commonwealth look so bad. It's so overt. This is another situation where, it would be nice to hope for some type of reflection and insight and a learning moment type of thing. But I'm just very skeptical that there's going to be any of that from her either.
Yeah, like, how do you, like, do you think, I want to play devil's, not play devil's advocate. I want to give a benefit of doubt for a bit, because I want to look at how she dealt with all the experts. I will say this.
Mm-hmm.
In my opinion, I think she was a bit consistent across the board, because she didn't want the experts to go into a shouting match with one another, and wanted the data, just what they were saying, to come out. That's what I personally thought was going on when I saw she wouldn't allow certain testimony to come in where one expert critiques another and another. Personally, I was like, I wanted to see that, because I've never seen a trial where an expert wasn't allowed to critique. The murder trial had experts going at it, and even Debbie Heard, like you saw Dr. Hughes basically go at Dr. I forgot her name, Shannon Curry. Go at each other. But this one, I like, do you think that was the right call? Like, what do you think she was trying to do? Like, Yeah.
She was trying to put her thumb on the scale, Hines. And so this is one issue. I am going to have to respectfully disagree with you on this one. To me, the experts were like one of the most obvious areas of her disparate treatment of the parties, and where that it really became clear with Judd Welcher, but it started to become clear with Ian Whiffen, where we remember the bar that was in place for the defense to be able to present expert testimony. All that Hank Brennan had to do is just say, I don't like their opinions. I don't think they're scientific. And we have to have, 3-day voir dire hearings that are effectively free depositions of the experts for Hank Brennan to be able to like test out what their theories are and so forth. So we saw that with ARCA. We saw it with Dr. Russell. We saw it with Richard Green, who ultimately didn't testify, just this demanding standard. And then, of course, Michael Easter didn't get to testify. It was just a very demanding standard of what was going to be allowed. Whereas with the Commonwealth's witnesses, not only was it extremely permissive, there was not a single qualification hearing that was needed for any of the Commonwealth's witnesses. But then once they actually testified, it became so clear how unfair that was. When you have Ian Whiffen on the stand testifying, well, I put the phone in a freezer and it did some things, and I don't have any idea what any of that means. Like, it's not, he himself is admitting, like, this is not a systematic process. It doesn't prove anything. Then why are you allowed to testify to it? That is literally the gatekeeping role of the judge with scientific evidence. But the real coup de grace was Judson Welcher, because at the end of the day, he made it very clear his testimony was not scientific. When it came to his engineering and everything he was able to do with that particular bit of information, he came up with, we can't ever know. It's too complicated. We'll never know what happened. But he's still going to opine that there was a car collision based on what? Based on all of the stuff that has nothing to do with engineering, nothing to do with science. So this is a classic example of somebody just assuming for themselves, I'm going to take over the role of the jury. I'm going to decide what I think, and then I'm just going to express that as my opinion. There's nothing scientific about that whatsoever. So for her to allow that after without even requiring any kind of a qualification of his scientific method, it was just appalling to me. It was so overt and so obvious what a double standard was being applied there.
Yeah, right. Local Express, thank you so much for your $2 super chat. I really appreciate you for saying this. He says, he or she, I don't know the agenda. I don't want to get cancelled tonight. Local Express says they ignored ring video, would have had audio clues. And I gotta say this because this was brilliant from Alan Jackson to ask the detective, the former detective, I forgot his name now, but Lieutenant Gallagher. Thank you. In regards to the Arlo camera, because why would you not bring just for the sound? Just you don't have to show the picture, just the sound of the like, and his boldness to basically say, no, we didn't have to. I'm like, you are supposed to eliminate all doubt that she did this. Like, the surrounding cameras would have been pretty evident. Like, do you think that, before I ask the question, actually, Juror 11 came out as well to basically say that she didn't even know which shirt the microscopic pieces was scraped from. Do you think that the Commonwealth, these are examples that they were not really forthcoming with their case to even present a clear, specific idea to the jurors, a methodic approach that this is exactly how it happened? Do you think these are examples of it?
Well, I think so. I mean, I think that's a problem if you're going to try to force the facts, and the facts are a square peg. You're trying to fit it into a round hole as far as your explanation goes. Like, there's always going to be mismatch and things that don't work. And I mean, the Ring camera video is just one of those things that, like, so when Proctor gives his interview, he's like, oh, maybe we would have done these other things just to say we did it. That's essentially what Gallagher said on the stand, right, about the Arlo video. Well, there wouldn't have been any point to it, like what, just to say we did it. Yes, sir, do it to say you did it. If nothing else, I think that would be great. That would give people a lot of comfort, knowing that you actually tried, because we're not idiots. And we know that in any other homicide investigation, you are up and down every single house on that street, on every street on the route. You are collecting every single bit of that video camera that you can find. This is 2025. Okay, cameras are ubiquitous. They are everywhere. And so to see not a single, like, nothing, no effort whatsoever to try to do something so fundamental to an investigation, to me, it just reveals, if they ask too many questions, that's, if they look too hard, like they can't, that would make their case fall apart. Like that's the tell that this is not the truth, and that in fact all of them know that that's not the truth. They have to stop asking questions and stop looking at the point where they've gotten what they want, because to go any deeper after that, it's your facts don't fit. It's going to make it, you run the risk of it being too clear that the facts don't fit.
Right. And funny enough, like, I'm glad this question was asked. Thank you, Law Kong. Funny enough, there is a trial that I'm watching right now. Is a Ronnie Walker trial. I'm working on a video for it. The investigators even had the neighbor bringing the ring camera just to show that the police were on the scene. That's it. They didn't even, it wasn't evidentiary to show a collision or whatever, just to show that police were there. And so when I saw things like that, and like, like watching other cases as well, I always found that very, very weird. Why would you not want to go and look at,
for example, to nail down the time frame? If we've got disputes about clocks and clock drift and when exactly did they get there, great. Their freaking route that they took from the waterfall. Go get every single camera along that route. It's not rocket science.
It would have proven as well that she had a broken tail light driving all the way back. I don't get it.
Yeah, it's very true. It's very true.
If, like, I want to ask you this. Like, I know you've been a criminal defense attorney for most of your career. Have you ever done prosecution work?
No, never.
Oh, okay. No.
Nope. Never done it.
Let's imagine that you were a prosecutor in this case. Would you have scoured the earth? The entire US. Even would you have gone to Poland if there was one doctor that would testify to there being lack of injuries in a vehicle accident? What would you have done? Would you have gone? Because
I don't know how you proceed in good faith with a prosecution when you don't have a single medical expert who will say this is possible that these were caused by a car collision caused these injuries resulting in death. I don't know how you go to trial when you don't have a single medical person who will say those are not dog bites on his arm. It's a completely different mechanism, and here's what it is. I think without those two things, it's always going to be a disconnect between what you're trying to say happened and what we can see for ourselves and what John's body says for itself about what happened to him.
I had to ask that question because there were some Twitter medical examiners, Twitter medical graduates, that basically told me that they have been in 60-mile truck collisions and they had no injuries whatsoever. So I was like, why didn't Hank Brennan call you? Like, it makes no sense. Like, you could have found. Is that possible? Actually, I don't know why I just got this idea. Would you actually be able to call somebody, like a layman that has been in an accident before and had no injuries whatsoever? Would you actually be able to call them and bring them in to testify?
No, because there wouldn't be any. There's nothing scientific about that. That would be anecdotal. That would be almost. It would be not quite propensity evidence, but like similar kind of character.
Allow it.
I mean, if they could have gotten away with it, I have no doubt that they would have tried. Because I think that would be the best that they could do. But it was always a problem, and you could tell from how they tried to play it every which way. You know, heads I win, tails you lose. Was it
Mm.
a direct hit? Well, it couldn't have been a direct hit because he doesn't have the injury that you would get from a direct hit. But he did end up 7 feet off the road, you know, 7 to 10 feet off the road. So there had to be, you know, some kind of explanation for how he ended up there. You know, so then we get the glancing blow, but then with the glancing blow, you have the problem of you know, the tail light, you know, having enough force to break the tail light to cause the injuries and so forth. There was always just a fundamental issue in this case that was bound to rear its head. I'm sorry, but Newton's second law is going to continue to exist. It's going to continue to be a problem for the Commonwealth, that the force that John exerts on the taillight with his arm is the same force that the taillight exerts on John's arm, if we're positing this type of interaction. And so you can't have a situation where it's like so much force that it shatters the taillight, and he has not so much as a bruise on his arm.
Yeah, absolutely. EB it says a question for KM Hines. If Karen Reed were black, at what point would riots have erupted?
Mm.
That's a very good question. Oh Lord, I don't know. I don't know how to answer this question. I actually don't know how to answer this, because if that was nah.
We've talked a lot on my channel about some of the counterfactuals in this situation and how I mean, it is an important and not to be overlooked fact here that part of why this is unfolded the way that it is because Karen has the resources that she has to be able to put up the fight. I would love to have a conversation with somebody from Norfolk County about the counterfactual situation. What would have happened if Karen Reed had been indigent? Just walk me through it. Like, how does she get a lawyer? What are the standards for the lawyers? Do they have caseload limits that they have to do? Is there any kind of like performance oversight? What sort of resources do they have? Can she get experts? Does she have to go get permission from the judge to hire experts and to get funding for that? Like, to just draw the picture of what this case would look like if it were one of the hundreds of thousands of other cases that is just routinely going through the criminal justice mill every single day across this country without, you know, those advantages that she had and the ability that she had because of that to generate the public attention and the outrage. I am very glad that she did. To me, it's nothing but a positive that she took those advantages and she did stick by her guns as a matter of principle. She's there to expose the corruption, and that's what she did. And a lot of people will benefit from that. And that challenge that she took on at great cost to herself personally, you know, financially, everything. She put a lot on the line to be able to challenge that system. So I very much, you know, admire her for that. But just also recognize had it not been her, had she not been in that position, very good chance we'd have never heard about any of this. It would have been a quiet plea and we'd be done.
Right. Yeah, like I don't think I also don't think that they're banking on the power of GoFundMe's and social media because because that sustained the case because
Yes.
and it's not like I don't think this case was a lot to do with a conspiracy more like, but I thought that personally a lot of the evidence that was coming out from the beginning was just not matching. Like I've gone back to retro because I haven't followed it from the start. I gone back to look at the hearings again and like, you know, not again, but the hearings from the start. I haven't fully looked at it, and I'm surprised at how the prosecution were actually trying to play this game with Lally. So the deck was really stacked against her when
It was
you
massively
consider-
stacked.
Yeah.
And had the FBI had the FBI not gotten involved, had
Absolutely.
the FBI not produced the TUI material, we would be looking at such an extremely different case. We wouldn't have ARCA, we wouldn't have the butt dials, we wouldn't have the 227 How Long to Die in Cold. It would have been so different. We wouldn't have had Jen McCabe and Kerry Roberts lying about that trip to Lank's house, and how, you know, nobody mentioned you went to Jen's house first, and then you also stopped by 34 Fairview for a little bit before you went over and sat in Lank's driveway for an hour.
Oh, that
Everybody
was
was like,
so
we're not
weird.
doing that kind of thing without the FBI. So just another like blessing in terms of like the serendipity of this case for Karen, because had they not done that, I think there's a much greater chance she's getting convicted.
Yeah, like I'm really happy I came into this case at least open-minded. I'm happy, like, because assessing the evidence, even without knowing the backstory, assessing the evidence was just not complete. Let me just read this super chat from Miss H Gold. Thank you for your £5 super chat, a fellow UK fella. I appreciate you, Miss Gold, for coming in and staying up with me, because I'm not alone here. I am up. She says, "Hi guys from the UK, thanks for covering this case. It's been a crazy ride, but they deserve outcome." And yeah, absolutely. Like, I'm glad that she has at least shown us in one way or the other that if you really believe in your innocence, you really got to fight for it, because end of the day, it's not handed to you. This, like, I'm glad you brought up the point of the indigent, because a lot of people from like, and I'm glad they asked that question about, you know, if Karen was black. If this was any other neighborhood, I doubt she would have taken this on. I think a plea deal would have been had, and all they had to say was, "Hey, you said I hit him. This person heard you say that. We give you a plea deal. You got to plea." Like, I think that I think just based on just that evidence alone, I think many would have just been like, "Okay, cool. I'll take the deal. I can't afford to take this on. Fine. Let me serve 10 years in prison and not life."
And let's not underestimate as well the fact that she's able to bail out, because most people in this situation, right, is you're thinking, well, I might like to fight, I'm innocent, but do I want to sit in jail for the next 2.5 years while they get around to taking me to trial? So many incentives in the system to push everything towards a conviction. So it takes enormous strength and persistence to not give in to that. And particularly in this case, with the added struggle that they had with the judge and the prosecution, and the dishonesty, the being misled, the misrepresentations, the shenanigans with, like, bring your expert all the way out here to download the DVR at the Canton PD to get the videos, and then lo and behold, there's nothing on it. Like, it was a constant battle that they had to fight the entire time, even just to get a fair shake. So it took a lot of heart on their part to get through this fight.
Yeah, like, yeah, absolutely. Like, and that's why I really think this case gripped a lot of people, because a lot of people just thought, if this was me, I'm toast. There is no way I could defend this. Like, so when you have people that really believe in you, I mean, me personally, like, don't hate me, chat, please. I'm not a big fan of Turtle Boy. I have seen how he does his thing when he was doing Turtle Boy Sports and all of that, like, long time ago, like before, like, him even talking about the case. I'm not a big fan, but at least he really stood behind what he really believed, an innocent woman, you know, like, and really stuck through. Because imagine if the Commonwealth actually came in and showed one video that showed her actually backing up. You know, that would have been like heart crushing for everybody. So, like, you know, I've got to give respect where it's due. You know, you know what I'm trying to say?
Yeah, I have this entire case. I have been ready and honestly hopeful that the Commonwealth would have something more than they did, because I don't like this kind of disappointment. I don't like this kind of disillusionment. I don't like this realization of how willing you are to abuse your power and lie and do this, gamesmanship stuff and all that. I didn't want that, but that's just the reality of what we had. They never had a technical case, and they never let that dissuade them from trying to make the argument. I think one of the things that's come out in the last few days that I particularly appreciated was that comment from the jury foreperson that, look, let's be real. If it was any one of us that had a dead cop found on our yard at 6 in the morning,
foreman,
the SWAT team is coming through our front doors. Okay. And calling that out for what it was, it's privilege. It's law enforcement. These guys sitting there behind their privilege, knowing that they're on the right team. They're the good guys. So nobody's going to be giving them a hard time. That I think just really summed up so much what the real heart of this case was, and one of the big problems they were always going to have to deal with. It's just they chose to treat these people differently, to treat this case in a way that not only did you treat it differently with the weaponized incompetence and so forth, but to do that, especially while you're at the same time trying to gaslight us about this is the death of a law enforcement officer, a brother in blue, etc. But you can't even be bothered to come out of your house to help. It was a bit much to swallow. So I did appreciate that perspective from the foreman.
Right, absolutely. Like, and I would never get it. Like, oh, why didn't you go out and give him help? Oh, I'm a cop in Boston, not in Canton. I'm like, what? I couldn't believe what I was hearing, because how does someone turn down a duty to help somebody if
so just about every jurisdiction, you've got multiple layers of law enforcement. You've got locals, you've got, different locals, and they might overlap in some areas around the perimeter, and you've got county, and you've got state, and then you've got, FBIs a lot of times in different areas. It is routine. Oh, and I mean, out where I am, then we have tribal police as well, is not super uncommon. And so they routinely have mutual assistance agreements, they call them, where nobody is concerned about where the jurisdictional line is. If you're law enforcement and you're in a position to help, the other law enforcement agency is not going to give you a hard time over that. They're going to welcome it and appreciate it, because like you spend half of your year bitching about how your budget's so bad and you can't afford to do all these things, but now here's this free help. You're going to complain about that too. Like, no, that's not how it works. It is routine to give assistance outside of your jurisdiction. So, it's just, yet another terrible excuse. They think we're stupid. They think that because we don't know, we're not law enforcement, so we don't know like how it works to be a cop. Like there's enough of us with enough experience, watching how these things unfold and understanding a little bit about what's beneath the hood when it comes to law enforcement investigations, that it just doesn't hold water.
Right, and I just finished watching. I'm not sure if you heard of it, but the Megan Jackson trial, and in that trial they tried to get a mistrial for the wrong jurisdiction, and I'm watching one county transfer jurisdiction over to the Horry County, and then after going through that case, saying transfer, and I'm hearing this guy say I'm a Boston. I'm like.
Just not how it works.
It just didn't click to me, but yeah. Claude Simeon, thank you so much for your $5 super chat. I appreciate you for saying that over. Claude Simeon says, Andrea dropping F-bombs makes my heart flutter for clarity. You're better than beer, not peated scotch. Laforag, 10-year cask strength FTW. Sorry for butchering that last part. I don't know how to spell properly, but I appreciate the super chat. Thank you. Andrea is amazing. Like, your coverage has been so detailed, has been has been amazing. To be honest, and I want to go back to what Hank Brennan did in regards to the mistrial, because when I saw that, I couldn't sleep. I just had to message. I just had to message you. Like, is that normal? Is that normal to get away from the mistrial application? Because I was scouring through case law that cases have gone up, and even when there was a curative instruction, that was still reversed. The mistrial that was not declared and the curative instruction gone out, it was still reversed, and they still had to go back to a new trial. So I'm like, why on earth did the judge allow that? Because to me, it tainted in my opinion, it would have had a high likelihood that it would have either prejudiced the prosecution to a high level if you did say he did this, or the defense would have suffered. I thought it was deadlock. Like, you can't do anything about it. You have to call it quits. So how come she disallowed it? Was it because of the without prejudice part, or because if it was with prejudice, do you think that would have got it accepted? Like, what do you think was going on there?
Well, I think at the end of the day, it's sort of a practical question, potentially. The judge does have some discretion to, declare a mistrial or not declare a mistrial. I do have to find a manifest necessity, and part of finding a manifest necessity is that there's nothing else that we could do that would possibly cure this harm, and so that's where the curative instruction comes in, right? If we can just tell the jury to do something, then that's we presume that they follow the instructions, right? We have this weird dynamic in criminal law where on the one hand, like, we recognize that some things are so prejudicial that you can't say them, you can't reference them, you can't bring them in. On the other hand, if the prosecution does it, we'll just tell the jury to disregard it and it'll be fine, guys. No problem. It's fine. But I think at the end of the day, it's kind of a practical question, because it's only an issue if she gets convicted, right? If the jury relies on it anyway, if it does have an effect. And so at the end of the day, it turns out it didn't matter. I have to wonder if we're at the point now in the case when these decisions are being made, like, do you see the writing on the wall? Is that part of what's feeding into some of this decision making? Like, you already know what an uphill battle the Commonwealth is going to have to even get a conviction here. So just go ahead and, I think Bev wanted this trial done. I don't think she wanted a third mistrial. I don't think she wanted this case to be retried. I think that she wanted some kind of finality more than she really wanted a particular decision. She was still going to do what she could to, keep the ball over in the Commonwealth's court as much as she could. But at the end of the day, I think the number one priority was just not have to do it again. This is too much work for Bev. It's annoying. They're having to do 5-day weeks, all that it's like terrible. So we just need to wrap that up and not have to worry about it anymore.
Right.
And a mistrial, of course, doesn't achieve that. A mistrial is we come back and we do it all over again. No, she doesn't want that.
Right. And also I just want to say, I just want to ask this question. Because I look back on it and I'm like, do you think, because I look at, Twitter law school graduates, they were all saying that Hank Brennan done a magnificent job, and they made the right choice to basically say that we're not going to go for a rebuttal, that's it. He didn't go for a rebuttal testimony or case, or I don't know what the exact term is, but
rebuttal.
Rebuttal. So do you think that was game changing? Like, because there was a lot of things that they could have tried to salvage their case from. I mean, forgetting the defects. They could have had an element, like, was that a good move by him, or was there more to play?
I mean, my impression is that it really was a necessary move by him. He really took the possibility of doing a rebuttal case off the table when he started with those shenanigans with the sweatshirt, and suggesting that the holes in the back of the sweatshirt, could have been from road rash, and then kind of built up with the x-rays and Welcher claiming, well, maybe his hand was broken because we'll never know because there weren't any x-rays. And so whether John had any broken bones was an issue that had never been in dispute up until Judd Welcher got on the stand. I saw a lot of people wondering, like, well, why didn't we see these x-rays before? Is this new information? Where did it come from? I seriously doubt it. Nobody questioned that there were no, Irini Scorti-Bello testified in the first trial, John had no fractures below the neck, and nobody ever disputed that. So there's no need to put the x-rays in. Like everybody is looking at the same thing and reaching the same conclusion. So it took Judd Welcher to come out and question that. And it did. It put them in a very tricky situation where, the defense now has the x-rays, gets them into evidence through Dr. La Posada. So we know they're going to be available for confrontation with Judd Welcher. And now the question is simply going to be, was it you and your negligent, sloppy overlooking of material, Dr. Welcher, that led you to make this misstatement? Or was it the prosecution that willfully withheld this information from you so that it wasn't a part of the materials that you reviewed? There was no good conclusion to this storyline of the x-rays for the Commonwealth. And I think Hank was smart enough to see that coming. He realized that there was, after we already had the contrast between what Dr. Welcher did and claimed in his paint test and all of that type of thing versus what ARCA did and the testing that they did that was so extensive and comprehensive and very scientific. We already had this huge counterpoint between those. So it's already a little bit weird to try to bring Dr. Welcher back on to criticize the guys that actually did something. Like, he threw up his hand, said, there's nothing we can do here. Okay, well, ARCA's like, well, we can do it then. So there's just minimal upside, and they had this massive downside looming of the potential for something really bad to come out around these x-rays and in the handling of these x-rays. And so it just took the wind out of the sails of any potential for rebuttal. I don't think you really had a choice.
Right. And oh yeah, by the way, sorry for leaving. My camera had overheated, so I had to turn it back off and turn it back on again. So yeah, that's why you saw my chair. Like, anyway, yeah, that's because that's a great explanation, because I was seeing a lot of opinions in regards to how prosecution would jump at a chance to rebut at a defense case, and I personally thought, I was really hoping, that they would have at least, I don't know, put on a rebuttal case, but only bring on a medical examiner and basically say, this person has treated people that has had no injuries with it, something like that. But he just completely he just completely gave up. It's as if that was it for him. Yeah.
Yeah. And I thought it was really notable, not even Dr. Crosby, like, after this whole fight that we had over the dog and the forensic dog odontology, and all of that stuff, all that nonsense with Yuri Buchanan having to hunt down Cora with her new family. She's Cora now, not Chloe, because she's in shepherd protection.
Cora in Vermont.
And at the end of all that, we didn't even get Crosby to come in and say, like, those aren't dog bites. It makes me wonder if he was ever going to be in a position to try to say those aren't dog bites, or if it was always going to have to come down. Well, but they weren't Chloe's bites. I don't know.
Oh.
I did that actually made me question a little bit. So, some of those decisions, it made me question a little bit, like whether Hank really had ever intended to put on a rebuttal case, or if this was just kind of a head fake to try to get the defense to do something or anticipate what he was going to do or where he was going to go. I really don't know, but I think at the end of the day, like the Crosby question, it still like sits out there bothering me. Like, if you had a good faith reason to call this witness in the first place, it's weird to me that you just completely threw that away in rebuttal. I mean, it's entirely possible he just gave up and quit. And I was getting that impression by the time we got to Dr. La Posada in the defense case, and she started, started just handing it back to him. I don't think he was hit by a car at all. Kinds
That
of
was
things.
probably
And
the best part. Like she was
it
so
was,
convinced.
and then
She was so
Rentschler picked
convinced.
up on that too, and you could kind of just see the spark go out of Hank at that point. So maybe he just gave up. I don't know. But I did. I had real questions about that. Welcher, I can understand. He was booby trapped. There was no way to call him for rebuttal. But Crosby, I'm still gonna be I'm gonna be curious about that and that decision.
Right. Yeah. Like. Also, like, I don't matter it doesn't matter how fast the car was going. It didn't get hit by a car. that has got
matter.
to me. That has got
And
to
that's
be the phrase of the
such
trial.
a beauty of that focus by the defense. That's such a beautiful part because, oh, she said I hit him. Who cares? It doesn't matter. People say a lot of stupid stuff. I say stupid stuff sometimes. It doesn't matter if she didn't hit him. Nobody cares what she said.
Right. Absolutely. EB, thank you so much for your for gifting 5 memberships. I appreciate you for that. Thank you. And whoever got those memberships, I hope that you enjoy them, because I do release a lot of content on here, and hopefully you guys will enjoy seeing it early. On civil law is in the chat. He's thanks for joining. He says Twitter law school is a broken and sad place. Avoid. I appreciate you.
Yeah.
Thanks for joining. Thanks for joining the stream. But and I appreciate everyone that has been sending their super chats over. One of them is here from Melissa Garcia, $4.99 super chat. I appreciate you for this super chat. Melissa says, I can't believe they said to the test dog. Let me start again. Sorry. I can't believe they said to test the dog DNA when there was no dog DNA found on him, but pig DNA.
Yeah.
That interview made them look horrible. Thoughts? Yeah. What are your thoughts on that, Andrea?
There's a reason why sometimes you should just not talk. Just the advice is given. You have the freedom. Snip it. Just.
Oh gosh, yeah. Like I'm like I gotta admit, like what Brennan did by even bringing in that testimony about pig DNA. If you remember, like, and there was no testimony about it, and Alessi was right to bring it up. The fact that we had him say we're going to cure it in rebuttal, and there was no rebuttal. Like, to me, does that happen at all? Like, where someone says that they're gonna cure something, and they just abandon it? Like, does that happen at all? Because I felt.
Well, I mean, it clearly did. It clearly did happen. But is that normal? No. This is not a normal courtroom. It's not a normal judge. When something like that happens, so this is an issue that's like conditional admissibility is kind of the legal concept behind it. There's nothing wrong inherently with asking Dr. Russell about the significance of the DNA results, as long as we know those DNA results are actually going to end up in evidence, because you have issues with confrontation of the person who did the testing and so forth that need to be established before that's in evidence. And so it's not unheard of to admit things conditionally, like, okay, we don't have all of this in yet, but it's going to come in. So we'll go ahead and just, we're not going to be super formalistic and make you stop and call that person in and get this in and then come back to Dr. Russell or whatever. We'll just allow it to go kind of out of order. But that is conditional. That means if you don't do it, then it's not evidence. It shouldn't have come in. At a bare minimum, there should be, a direction to strike, to the jury to strike that particular bit of evidence, because the condition was not satisfied. But it's worse than that here, because you have that underlying issue of the confrontation problem. The fact that there was a witness who did this DNA testing, who never had to appear on the stand, never had to be cross-examined. We went back and looked at her testimony from the first trial too, to like get a sense of whether there were any issues there that the defense may have wanted to focus on. And there were some concerns about interference with the test, its ability to be able to detect DNA, dog DNA in the first place, in part because of the handling, the environment, things like that can affect it. So just not having the ability to be able to go down that door is not something that you can cure. So a normal judge, I think, would have been hesitant at best to admit this evidence under those circumstances because of the confrontation implications.
Yeah, which is why I'm surprised that she didn't give a mistrial over it, and because I'm very so there were two mistrial applications that I thought was really strong. Like like I kind of understand the hose one a bit more, but the dog DNA one, that one I would never understand, because like that to me is Hank really desperate, really trying to railroad Karen and make sure that she doesn't have a chance to even present this dog idea, like which I'm like, if you really want to do that, just bring in just bring in the witness and just get him to testify that there was dog DNA. Why would you not do that in your case in chief? Like is their witness, isn't it? Terry Kuhn is their witness. Why didn't he just call her up and just get her? That would never make sense to me anyway. Yeah. Sorry. Dr. Russell's GASPS. Thank you so much for your super chat. I appreciate it. Says, I have never noticed you before. Now I'll go back on replay. Thank you so much. Karen is freed. Now justice for John O Keefe. I'm a nobody, guys. I will like, that might
guys, Hines is a good time. Don't let him undersell himself.
I always do this. But do stick around. Like I do have some jokes here and there. Like, I graduated from Twitter comedy school, so there are some jokes that you can catch that you can hear from me. So yeah.
But are they about your mom? We had fun. We had fun with the mom jokes, just being teed up right and left in this trial. I mean, you can't be giving me abdominal thrusting and not expecting me to run with that. Come on.
I bet your mom knows about thrust. That was probably the highlight.
Sometimes it just needs to be said.
Absolutely. So I before I ask my next question, I just want to read this latest super chat from Brandy. I appreciate your generosity. Thank you so much. She says, for the $19.99 super chat, I appreciate you for this. She asked, well, I hope Brandy is a girl's name. I'm gonna stop before I get cancelled. Yes, I love Andrea. I watched her channel the whole trial. Also, Hines, I found you when you posted a tweet asking for anti-free Karen Rios. If they would discuss their view with you, you shared my tweet. I appreciate you for that, Brandy. I do remember that. I don't think I'm gonna get someone like I'm still gonna leave the invite open, because I really want to have this discussion. I really want to have them sit here and just lead me through why they believe this collision happened, like why they believe that the investigation was pristine, because I always hear that. There's so many things that I really want to ask without, and I'm not challenging. I'm not a challenging guy. I'm a very open-minded guy. So if you're watching this, anyone from the other side, and and you feel like you want to talk about this case, let's talk about it, because end of the day, I don't think she got away with it. I don't think she got away with anything. I personally think that justice was served. You may not like it, but it was Karen Reed on trial. It was her. Like, she had to defend herself. Like, you know, like if the police cared about justice for John, they would have. I still can't believe that they didn't even cover up the scene, like, you know, with their crime tapes.
Yeah.
Like, I've never
Yeah.
seen a crime scene like that. I just haven't seen a crime scene just left and everyone gone off. That doesn't make sense. Like, but
No, it doesn't. It doesn't make any sense.
but that's the weird part about this case. That's the weird part about this case. But yeah, I appreciate you for your Twitter, Brandy. I wanna ask, because the civil trial is coming up. Like, what do you think is gonna happen with that? Do you think she's gonna settle? Do you think she's gonna fight it? Do you think it's gonna be televised? Like,
Yeah, I doubt it. You know, the thing with the civil cases is that they typically get handed over to the insurance companies like almost immediately, and so your actual ability to like drive the strategy and so forth is pretty limited. Most people are not Amber Heard getting their you know, insurance company to pay millions beyond the policy limits and so forth. Most of the time, the insurance companies are they have the authority to make those types of decisions and are going to do what's financially in their best interest. So a lot of that decision making, I think, is ultimately not going to be in Karen's hands, whether it gets fought or doesn't. Civil cases overwhelmingly, of course, do settle. Very, very rarely go to trial. So that is the norm. That would be the prediction. If I'm the Vegas bookkeeper setting the odds, like the odds are heavily in favor of the case settles. And it's not to any kind of comment on the merits. It's really just a comment on civil litigation, particularly when you have insurers involved.
Have you seen what's been happening to juror number 11 on Twitter? Like, what's been happening?
Oh yeah, how she's been getting like doxxed and harassed, and she's being called an illegal and all kinds of like awful racist things. Yeah, I've seen that.
Yeah,
I've seen that.
Yeah,
Well, a lot of concern for the witness intimidation statute right now by, you know, Tully, who was so concerned about the witness intimidation statute that he wrote like a 30-page report against Turtle Boy for witness intimidation. It was more thorough documentation than John O Keefe ever got for any aspect of his investigation. And yet, you know, not hearing any kind of indication that there's any concern about a juror being harassed like this.
right. And I gotta play this because this post was by Maga Barbie. She found this video that was done during the verdict, and it's very interesting how things have changed. Let's listen to it, because this is the people that believe that Karen Reed was guilty and she should get guilty. Let's listen to this.
Anyway, like, no matter what happens, please, like, we're gonna leave the jury alone, okay? We're gonna leave the jury alone.
Of course, yeah.
This is
No, I
not
don't
free
have
Karen
the
Reed.
No, it's not.
Well, I want to hear.
Yeah,
If they choose,
Yeah.
going after
they
him.
That lasted like 5 seconds.
know who they are. Nobody
no.
needs to be angry at them, or if it goes
No.
your way, weirdly obsessed with like patting them on the back or whatever. They're doing their civic duty.
Right.
I love it.
Anyway, like,
I just love it.
Yeah.
I just love it. The grandstanding and all of that, and then when it doesn't go your way, oh no, Maso Mafia is like, you know, no, you're illegal. You didn't take the evidence seriously. All those things. Like,
Yeah.
I'm just glad that the jurors out there are showing. They at least show that, you know, that they really took this process seriously, and they really deliberate on the evidence, because the same juror that they're even going after had said that she doesn't believe in the Google search, that the prosecution had done a good job in proving that the Google search did not happen at that time. So they disregarded that, which makes me wonder. The prosecution went so hard for John McCabe, you know, to vindicate her. Like, they put on a better defense, a better case to prosecute and say no, John McCabe didn't make the Google search. They put on a better case for that than the collision. Like, so were we duped in this case when we see things like that?
Oh, Heinz, that clip to me, it just underscores why I continually voice the refrain that talk is cheap, and that what people say is like one of the worst forms of evidence that there is, because no matter how hard people are trying, most of what you say is colored by your view of who you think you are or want to be or want reality to be, and so forth. And it's just not always a good fit with what actual reality is, or who you in fact are deep down when you don't get your way, and what what you want. It's easy for somebody to spout principles. It's much harder to actually live by them, and so seeing the actions will always speak louder than words, and that's where I think the treatment that the jurors have been receiving really does speak volumes. But having said that, juror 11, Paula, she's a badass. Okay, she is she is kicking ass and taking names over on Twitter. These folks, so like I don't want to run into her in a dark alley. Okay.
And she does it.
I'll just cross over to that other side of the street. It's not a race thing at all. Like, no, I'm just scared.
No, she does it. I'm with you. She does it with such ease. Like it's as if like there's nothing that bothers her. She's like, okay, like by the way, make sure that you read my biography for my 5 minutes of fame. Make sure you're the author of my biography. I'm like, Jesus Christ. And they hate her for it. But yeah, on civil law, thank you so much for your super chat, for your $10 super chat. I appreciate you for this. On civil law is here, guys. But yeah, she says, I would love to get a second opinion on a question I've been trying to figure out. What is the res judicata and collateral estoppel effect of the DUI conviction on a 1983 suit from Reed against Proctor?
I don't think that there's going to be any, since Proctor is not a party, and so there isn't going to be the party against whom you're asserting it is got to be the person that had the prior opportunity to challenge it and be heard on it. So she doesn't have, as I see it, any res judicata or collateral estoppel way to like enforce the judgment that Proctor was not a party to against Proctor. If Proctor wants to assert it against her, then I think that would be possible. That would be on the table because she had the opportunity to defend it. You might get into questions of the burden of proof, but I mean, they found it beyond a reasonable doubt. So I don't think that's really going to be an issue. So I think it's a situation where, depending on, they probably in Massachusetts follow the majority rule. Remember, Virginia back in Depp v. Heard didn't, where both parties had to be the same parties to the lawsuit. That's the minority rule. In most places, just the person you're trying to use it against had to have been a participant in the earlier action. So if Massachusetts follows the normal rule, then it would be a situation where Karen couldn't use it against Proctor, but Proctor could use it against her.
Okay, but that's what on civil law says. That's what I meant. Proctor asserting it against her was my concern. Okay,
yeah,
okay,
yeah.
Thanks for clearing that up. And thank you on civil law for the question. I never would have considered that. Like, this is why it's good to go to actual law school and graduate from actual law school rather than rely on Twitter law school degrees. Everyone, this is a fine example. So I hope the Twitter lawyers are watching. But yeah, let me continue on. Idaho Kelly, I share Andrea's thoughts that Hank Brennan never intended to actually do the rebuttal. Would have been a KO. Absolutely. I think it was. I'm sorry, that guy was beaten up, man. I saw the way that he asked the question in regards to in regards to Dr. Wedge's report. Like, he paused and thought about it. I knew he thought about it because the minute he asked the questions, like, you don't No, exactly. I was like, oh my God, you're finished. The minute he
Yeah.
paused, I was like, oh my God, he's actually done. He's actually going to go here. He's like, you don't know the posture that Dr. Welcher was standing in. Like you don't know that Dr. Welcher never said that he knew the posture of John O Keefe, that he never knew the hand position.
And then the way they handled that, but being like, so then why did he do that? My bad. I'm totally willing to be corrected on, because I didn't assume that it was a pointless test that he did. So thank you for clarifying that. Like,
that's got to be the best moment, because he kept, and Dr. Renshaw as well, he kept sending the jabs. It's like, okay, so this test that well, apparently we don't know if John O Keefe was even standing now. So this test
apparently was for no reason.
which apparently never happened. But yeah, like it was like when I saw that, like to me, Hank Brennan was just done. He knew he's been out lawyered, and to me, I think he was just unprepared, because for me, I would have just hired anybody just to come on and just say, look, this can happen. This can, not Dr. Welcher that says, trust me, bro. I've done the reconstruction.
I mean, the car could just blow up into space. Like, if that's possible, then like anything is possible, right? From an engineering standpoint.
I can lie back on my bed and blow my load. I can't believe an engineer actually said that. I can't believe it. But yeah, thank you so much for the super chat, Idaho Kelly. Mala Hooch, thank you so much for your super chat as well. Says Andrea, thank you for supporting the other content creators this week. You're a gift to this community. Yes, she is doing her civic duty as a lawyer. and I love the fact that Alessi really gave you your props. That was worth staying up for.
Yeah, that caught me by surprise. I wasn't expecting that for sure. That was quite flattering, and I didn't really know how to react, to be very honest.
Yeah.
Oh, I think we lost his camera again for
Sorry,
a moment.
It happened again. I'll be right back.
Yeah, no worries.
Okay, so okay.
But I want to give big props to Ian for getting that interview. I was just so pleased to see that he was the one that landed it. Could not have happened to a more stand-up, fundamentally good and decent human being. We all knew he was going to kill it. He was going to have a great conversation. He absolutely delivered on that. The type of back and forth that you're never in a million years going to get from mainstream media. You have to go to independent creators to get something like that. I really appreciated them giving him that nod as well. And just recognizing what I think so many of us over here in this little corner of the internet have started to realize, which is just that, this is a new era when it comes to watching court and sort of monitoring what's happening in this particular branch of our government. We can't trust the mainstream media anymore, and it's unfortunate. But that's just the way it is. That's just the reality. And so for them to not be, I think, afraid to not only call that out, but actually put their money where their mouth is and go on Ian's channel for that interview really spoke volumes just about where we're at in terms of the media culture and just who you can trust for information.
Right, like and it was like, I know they couldn't talk much in regards to what they knew about a trial, but like that little nugget alone of their even having proof for what they were even asserting, I'm hoping I don't think she's gonna do it, but I'm hoping Karen just makes a website and says, look, I am really innocent. I am really innocent. Not what Dr. Lou said. I am actually innocent. Here's all my proof.
I would love it. And I mean, I think she deserves it. Her life We described it as it's a smoking crater in my channel. That's the reality of the justice system, and we kind of talked about this a little bit at the beginning. Once you get that accusation, your life is over.
Right.
And so whatever future she has now, it's going to have to be something new that she builds. And I would absolutely love to see her take advantage of what she's gone through and what she knows and the information that she has. And when she's able to do that, make millions of dollars off of her book, off of her movie, off of her rights. Girl, go get it. If anybody deserves it, I think she does.
I hope she doesn't throw and write "if I did it." I hope she doesn't.
I would kind of love it if she did, honestly, like out troll the trolls. That would be genius.
I know Paula would.
Paula would absolutely.
If I snuck into the jury.
If she did it.
If I snuck into the jury.
Yeah, if I were a secret jury plant. No, Heinz, I don't know if you heard. I had my idea out of all of this, my big takeaway. I mentioned it to Ian a little bit ago. But I have envisioned like my creative project. If I were like a more creative person and better able to kind of get things like that done, this is what I would do. I would write the graphic novel of the Karen Reed trial, but my twist for the graphic novel story would be that Hank Brennan is the secret FBI plant. He's the one that came in undercover. See, and it was all just to be able to get the information about the cover up and about the hoax and about Morrissey and the corruption and all that type of stuff. He was never actually supposed to get through this trial. But the exit ramps kept being taken away because, for example, he would have thought that, like, surely if I present this Blue Man Group accident reconstructionist as such clearly ridiculous nonsense, it's not, no judge is going to let that in, right? But who knew he's flummoxed by the fact that he's got this judge that's actually letting him get away with the stuff that he had counted on not being able to get away with, and being able to like exit ramp the case. And so he's stuck in the case. And I can absolutely see a world where you could re-envision this trial and the decisions that were made over the course of this trial through that lens, and it would actually make sense.
I would buy that book. I don't read much, but I will buy that graphic novel. Absolutely. Could you imagine Hank Brennan coming out? It's like as an FBI plan. That okay,
I'm just saying, if you were a secret FBI plant and you had to try the case and you had to make it look like you were trying, but you also didn't really want to win, it might look a lot like this. I'm just saying.
Yeah, like that just reminded me, because there was something that Juror, forgot his name now, Juror 4, I think, Jason, that done it, the interview with TMZ. He said something that was interesting, which was the cover up, and he said we didn't even consider the cover up because there was not even there was no context to, like, the prosecution never gave us anything, the defense never gave us anything to consider, so we didn't even consider cover up. So we just looked at the evidence, and he said that the car driving from Meadows, and showing a white and then going back to a red as he was leaving, that doesn't make sense. To him,
solid red. It's solid red. You're telling me the tail light has been bashed out, but it's solid red. I have eyes. Like I could not take those off and leave them outside of the jury room to make my decision. They were always going to come in with me and be part of my decision-making process. So how the F do you think I would not notice that this tail light is red all the way across, except for that one little clip that you had to back it up to? You had to show me like 50 frames of red to get to that one where there's a little bit of white. What are you even doing, Hank? It's like, did you want me to see how red this taillight is?
Absolutely. And I'm glad that Jackson actually highlighted that and see, like they're saying that the taillight is high, but look, it's perfectly intact. It's perfectly and probably one of the funniest. I'm not sure if you're seeing this, but John DePietro, I'm not sure if you've seen it. The
where he
journalist
backed into the lady's taillight. Yeah.
in this trial where he was saying, and he tried trolling the police, saying there was no collision, while giving the police,
Yeah.
and while he let them know, he basically said that I was lying when I let them know. I was saying leaving a note to say that he saw who basically collided. There was no collision from him, and like it was so weird. But to see his car be the one to break the tail light, that to me was funny. But anyway,
Yeah. Karma's a beautiful thing sometimes.
absolutely. Absolutely. But yeah, Pat Tumbo, thank you so much for your $5 super chat. I appreciate you. Was there any testimony that established Karen Reed's SUV was in front of the house at 12:32 other than the trigger event? This is a good question, because to me, I've always wondered when she left. I know that there was, I'm not sure if the evidence came in with Guarino, but I know that the Wi-Fi connected at 12:36 based on the old trial. I know that that the messages did not start coming in until 12:40 from Karen, and she even tried calling John at 12:33. So at what point did she leave? Because was it 12:38? Oh, it's gone up again.
Yeah, no, I mean,
what do you think?
that's really the million-dollar question, and there isn't really any particularly good evidence to be able to tie that down. It's not something that we know from the car. There had been a hint in the pretrial hearings for sure, and now I'm trying to remember if Hank brought it up in his opening, and I can't remember either. But there was a suggestion that they had a time frame for John's phone disconnecting from the Lexus. I think something like that. And so that, at least in theory, would potentially give us a possible time frame for when Karen left the scene. Because of course you get out of range. It's Bluetooth. It's not a particularly strong signal. So once she's out of range, his phone isn't going to be able to stay connected anymore. But that never ultimately came out in the trial. Like, it got sold as something that was going to be really incriminating, and then it just never even happened. So my suspicion, of course, because of that, is that, well, that means that wasn't favorable information for the Commonwealth. It wasn't a good time for them and for their theory. And like Mr. Alessi said, this was a situation where seconds mattered. So if you weren't prepared to account for the seconds, then I just don't know how you try to make any kind of affirmative claims about who was where when.
Right. And I always found it weird. I mean, as much as they want to present that Techstream data, I find it weird that Karen backed into John. Forget the steps that John was taking. I can give the benefit of the doubt for the 4 steps that was unaccounted for, that a trigger event was given. I can give the benefit of the doubt. But what I don't understand is, how is she reversing and hit John, and a few seconds later places a call to John driving, and it's a missed call. That never made sense to me. To me, that you don't drive at a high speed in reverse, and then you put a call to the phone after. That would never make sense to me. But that was the date. The date, as Angla saying, the date is there. It would never. It doesn't make sense that she would drive off and then call him while she was driving at high speed after, backing up. So
very little of it made sense to me. I mean, how there's this murderous rage that arises out of the mere existence of Bella's mom is not something that was ever satisfactorily explained to me. Like, she's clearly aware that Bella's mom exists. So what even is this trigger? Like, I'm afraid I'm going to need a little bit more of an explanation about how this leads to a murderous rage, beyond just the sort of misogyny, like, oh, we're going to try to paint her as a psycho. We're just going to try to paint her as don't put your dick in crazy kind of situation. But then the whole after the fact activity as well. Like, I'm sorry, you hit somebody and you left them to die. You are not leaving them John, I hate you messages on their voicemail. Like, what on earth is the Commonwealth even thinking? If you hit him and you left him to die and you're leaving a voicemail, it's John, I love you so much. I miss you. You're covering up what you just did. And so you're going to be like playing up that there's nothing wrong, that everything is great. It just, the whole theory of it never made sense from a psychological standpoint either.
And to me, they even went ahead to even prove that there would be no collision as well based on the voicemail, because they gave you the preview of they having a rocky relationship. So automatically, when they made up at the waterfall because of Christina Kafalakis, I don't know how to say her name properly, but I think
Karina Kolakithis.
Karina Kolakithis, that's the one. Apologies. But yeah, like after her testimony, like they clearly made up at the waterfall, but that doesn't just erase the insecurities that you've already proven that you had, you know, with the jealousy and all that. And then you kill someone because of jealousy, and then you go on to be more jealous when they're dead.
I mean, for me, a big part of what undermined the Commonwealth's theory about all of this is just the texts themselves that we see between Karen and John. We get to see a little inside view into the relationship, and you know, probably lots of people are going to have different perspectives on it, different judgments on it, and so forth. But my read into it when I read those texts, I see one person that is trying to appease, one person that is trying to make peace, one person that is trying to get some type of resolution, and one that is withdrawing and pushing away and being dismissive and minimizing the other one's concerns. And so to me, that's the dynamic that all of this kind of has to be taking place within. And I just don't see a universe where suddenly, you know, Jen McCabe saying Bella's mom suddenly switches the dynamic, you know, to this massive extent where this person who has been, you know, willing to kind of put her pride aside and be like, I'm trying to make up with you, trying to reach out, trying to say nice things, trying to encourage you, now just becomes like murderous rage. Again, it's just never made sense to me. None of this is consistent with what we could actually see.
Right, absolutely. Bird, thank you so much for your $5 super chat. She is just a emojis dancing like a bird. I appreciate you. I appreciate you for that super chat. Thank you so much. Sadie Neal, thank you so much for your $9 super chat. Sadie says, Andrea, do you remember last trial they brought up Jen taking donuts to the Alberts for the birthday tradition?
Julie.
I wonder why they didn't ask her about it in the second trial.
It was Julie. That was Julie Albert during the first trial, because she didn't have a very good explanation for why she had shown up at 34 Fairview in the first place, right? Because nothing has happened. There's not like, you know, frantic activity of word getting out and everybody trying to get their story on the same page or anything like that. No. It was just a perfectly normal, just like every year with Brian Jr.'s birthday, I go and get him the donuts, and then for some reason it makes more sense to me to leave them outside in the car in the blizzard that nobody's probably going to be getting into, right? Because it's a freaking blizzard. Nobody's driving anywhere. It was a terrible story. But that was Julie. And so I think that's part of why that didn't come out, is just because she didn't get called as a witness this time.
Yeah, like I think I think that really harmed Hank, because he would have given a lot of context. I mean, I know why he didn't call it, because there was a trial already where so many people came out and made it a complete storm. But it would have at least given him a lot of material to work with, at least in establishing that everyone in there did not see him go in the house, because the jurors were like, you know, juror 11, she said, I think they went into the house. And to me, you can't blame her for thinking that, because end of the day, you don't even have enough people that were in the house to say we didn't see him go in the house. Like, even I think only 3 people said it. Who was called from the house? Jen and
Jen McCabe said it and Sarah Levinson said it, and I don't think there was anybody
And that's
else.
it.
I think it
And
was
that's
I
it.
think it was those two.
Yeah,
I think it was those two.
And Judy Nagel was in the car. She didn't
Yeah,
seem.
didn't call Julie Nagel.
Yeah, yeah.
So, I mean, this was one thing where I do not think Hank improved on Adam Lally's case at all. I think this was one area where Mr. Lally by far made the better decision at
Mm,
trial, was to call all of those witnesses, like you're saying. And there were a number of benefits to it. One, it kind of forced the defense to be defensive about them.
mm, mm,
To figure out how you're going to attack them, what your angle of attack on them is going to be. But it plays off of that argument that we've heard a million times, right? Well, how could there be, you're saying there'd have to be like 20 people involved in this conspiracy for it to work. There'd have to be 50, the whole town, like, no, it doesn't have to be that bad. But if you call 8 people that were in the house and they're all saying we never saw him come in, yeah, the
mm.
defense has to have an explanation around that.
Yeah,
Either these people aren't credible, or they didn't see for some reason. There could be some other type of explanation about it. So in this particular case, Hank Brennan really hung all of that on Jen McCabe. It was going to be kind of win or lose that on the credibility of Jen saying we didn't see him come in. And I don't think that was a smart gamble. I really don't personally
10 buck
think,
thousand.
that one paid off. It would have been stronger. It puts the jury in the position when you can see the people and they're humanized. You can get a sense of them and kind of evaluate them and stuff like that. And the jury would then have to be asking themselves, do I believe that this living breathing human person here would be lying to me about that? And it's a lot harder to reach that conclusion about somebody right there looking you in the eye saying these things than it is about just a person you're imagining in your mind. So overall, I think that was a very smart decision by Lally to call all those witnesses in the first trial, and a major misstep by Hank not to.
Right. Yeah, it definitely would have. I mean, I think this would have been a miss. I don't know. I mean, based on what the jurors came out, they didn't want this to be a mistrial because the testimonies came in on the first trial. There was mention of it, of the first trial and all that, and he may have gotten a manslaughter. He may have. I think because I mean there were some points again going great for him. I think the phone point that he brought out and says the phone activity doesn't move at all from 12:33 until 6. I think that's a brilliant point.
Great fact. It's a great fact.
That's a brilliant point, but
yeah,
you don't back it up with people definitively saying no, he didn't come into the house. Were there other points for the prosecution that was, what else do you think that the prosecution did good? Did they do anything good, do you think?
They really didn't do much. They really didn't do much very good, from
I
what
did
I can say. I try to be generous, but I'm like scratching my head. Did they do something good? You're going to really put me on the spot with that one. I think the most success, I've mentioned this before, that I think the most success Brennan had, if I were going to like highlight a moment that was like the high point for Hank Brennan in the case, it would have been that cross-examination of Officer Barros, because I do think that was effective. That was extremely powerful evidence that Officer Barros had about the taillight is absolutely not in that condition. And he was able to get Officer Barros in a situation where his memory has become suspect, regardless of the tricks that he played and so forth to kind of get him walk down that road. Nevertheless, Officer Barros remembered this event from the first trial that just did not happen. And we knew it hadn't happened. We'd watched the first trial. We'd talked about this, the fact that Barros had not been shown a photo of the taillight in the Sally Port and asked, because it was one of those nuclear questions. Somebody's case is getting blown up in that moment if they don't know the answer to that question. So everybody's afraid to ask it. They very deliberately did not go there in the first trial. So as soon as he, testified that, yes, he had been shown it and he had this memory, I was like, oh, that was big. That was big by Hank because you know, the jury would be justified at that point in just in you know questioning how valid his
Right.
memory is. We can't say on the one hand, you know, Timothy Nuttall is clearly not right about what he remembers because it doesn't add up with the video evidence. And at the same time, you know, just have a different like if we're applying a consistent standard, then I think the jury could have potentially minimized that evidence. And it was such important evidence that it was critical for him to undermine it. So I
Right.
do think that was probably his high point,
Right.
the closest that he got to really making the kind of progress that might have gotten him a conviction. Obviously, ultimately, he couldn't keep that up, but but
Right.
that one moment he had, I thought he was successful with that.
Right. And what do you think was the defense best moment of this trial? Like, what do you think was the case decider, in my opinion, based on the
Oof.
verdict?
I mean, it's gotta be for me, La Posada with the I don't think he was even hit by a car. Like to me, that was really the turning point. To just she's such a consummate expert. She knows this game, the system with the trial in and out. She knows all of their tricks. She's been doing this for a million years.
And she
You know,
was so calm.
he's going to try to impeach
Yeah.
her on the fire, and like I guarantee you she has answered that question so many times.
Mm.
She's like so
Dude,
prepared for
yeah.
that. There's no way you're going to get anywhere with her on that. And she knows how to find openings and punch back. And that whole I don't think he was, you know, even hit by a car was just a great example of an expert who is primed and ready and waiting for their opportunity. And that was it was really a death blow, and she delivered it with such incredible grace and skill. It was a beauty to see.
Right. Right. And yeah, like I really appreciate, you know, all that you've done in this case. I really appreciate your insights in this case. And I'm looking forward to your Idaho 4 murders. Like I mean,
Mm,
it's getting live stream, right? I hope that you're not
it is.
choosing the court. I hope that you're not going to court, because please don't go to court just to be a geek and like look for the exhibits, and like please just live stream it, because I want to.
Well, you know, I've been looking at this over the past few days because I have been kind of indecisive about obviously I'm going to cover Idaho 4, but I don't have a firm decision yet about exactly what that's going to look like, how it's going to be. It's very convenient for me to be in Boise and to go to court, and there's a lot of good reasons I think to get that perspective. There's some value to having that perspective from inside the courtroom. At the same time, because it is, you know, this isn't a situation where you have to get in to be able to get the facts. Like we're going to get the live stream. Everybody's going to be able to watch it. It's not like Delphi that way. So it's not like huge pressure to get in. It's not that clear to me that it's going to be all that feasible to expect to get in regularly. I was kind of looking at what the logistics of that are going to be, and they're going to do a lottery, which in and of itself is fine, but it looks like they're not having a media overflow room, so all of the reporters are going to be in the same like lottery for seats as the members of the general public, and so as soon as you include all those people in, like suddenly the pool for seats has gotten massive, and so I'm not really counting on probably being able to be in court on any kind of a regular basis. But I do want to try. So I mean, my plan for right now is I'm going to go for the jury selection, because that's not going to be streamed anyway. So the only way to see that is going to be in person. And then I'm just hoping from there to get the lay of the land and see, like, is it going to be realistic to expect to be in the courtroom, or should I just plan to go ahead and go home and watch the stream with everybody else?
Watch it with everyone else. Watch it with everyone else. Watch it with everyone else.
It is a fun way to do it, and I do enjoy it. I have to say that the sitting for all these hours, it's really gotten to me, Heinz. I am not the young
Oh
lady
yeah.
I
No,
used
no.
to be.
No, no. I really commend you, because I couldn't do it. I like I've tried doing trial watch. It's a different ball game. I admire every content creator and commentator out there that actually sits down and watch a trial, because I can't do it. I mean, I need to like I have a portable speaker that I just carry around to just to go, just to walk around the house and keep myself.
Mhm.
But I can't do that if if you're watching it live. So like I really do appreciate that sacrifice that each and every one of you do to give us your commentary, because it's worthwhile. I'll tell you that. Like there is
Well,
so much
thank
I've
you.
learned from you. Yeah.
I really appreciate it. I'm not looking for like props. Like I'm not a hero because I sit and watch TV and talk to people about it. Like it's it's not like I'm not having to overcome any major challenge to be able to do that. But it is just one of those little things that does it does add up. It's part of what I'm considering about how to move forward. But one way or another, there will be Koberger coverage. I will give you that assurance.
Good. Good. Okay. Like hopefully we can talk about that. Because I'm looking to make recaps of that. That's all I do here. Like I just watch the whole trial, get my notes as detailed as possible. Like your
Mhm.
note taking is inspirational. Your like when I saw what you wrote, on your stream, but yeah, but like that's what I do here. I just make it bite size so that everyone can watch day by
Mhm.
day recaps, etc. So I am
Mhm.
looking to cover that. I haven't seen the pre-trial stuff. I know
Mhm.
the nucleus of the prima facie, or whatever is the overview of the case. I
Mhm.
know what he's
Mhm.
being accused of, and the last thing I knew was the touch DNA being found, in the room that
Mhm.
matches back to him, and the cell towers, all those things.
Mhm.
So I'm looking forward to seeing what comes out in the trial.
Yeah.
But yeah.
It's gonna be a real learning one, this trial, because yeah, it's so much is in the dark. I feel like we're only gonna like we haven't scratched the surface on what's known about that case, about that crime. And
Mm,
so it's gonna be an awful lot of new information for folks to take in. I've been skeptical of the prosecution based on, just what's been public so far. But there's just so much that's unknown. Like we have to wait and see. Like I think it would be imprudent to have too strong an opinion about either guilt or innocence at this point.
right. I've seen a lot of people make their mind up already, and I really hate that
Mhm.
in regards to the process, because I mean the presumption.
Oh, overwhelmingly, the public
Yeah,
opinion is that he's guilty, like
yeah.
by ridiculous. There's not even really any question about it. So it's a huge hurdle that he's going to face at the trial, and the whole whether he's going to be convicted is kind of a different question than did he do it. So he's way behind the eight ball already on the is he going to be convicted, just based on the public opinion, the fact that they're going to have to death qualify the jury, death qualified juries by kind of by structure are predisposed to be more likely to convict, period. So it's a lot of hurdles for that case to overcome.
Before we call it a day, because I want to go back to Karen Reed for a bit. What do you think she should do now? Like,
Mhm.
she's finally gotten herself. She's finally free from any well, not from all litigation, but no
Mhm.
more trials, no more having that thought of, okay, they're bringing the case again.
Yeah.
There is no more of that. Just a probation that she has to contend with. What do you think is going to
Mhm.
happen with her now? Like how do you
Mhm.
normally advise your clients? When they have been acquitted, like what normally happens next?
Mhm. Well, I think the hard thing, like I mentioned before, is that her life as she knew it was over, and so there's going to be a process of grief that's associated with that. She has lost a lot, and we don't really know if she's had the space to kind of process that emotionally, everything that she's been through, because she went from dealing with John's death to dealing with being charged to this whole process of trying to fight for her innocence and stuff like that. And I would just it wouldn't surprise me at all if she's had to kind of defer having feelings about any of it, and just in order to be able to get through it. So I think the rule number one is just give yourself the space to do whatever you need to do to make sure that you're in a good spot, you're healthy, you're coping, you have good tools in place, you have good support in place, and all of that type of thing. But the second thing I would say, I would never presume to tell Karen like what she should do, what would be a good idea. Like that's going to totally be up to her. But just in very general terms, I think probably one of the most beneficial things that she could do would be to try to look at this situation right now as an opportunity, because it really is. She's at such a transitional point where her old life is over. This very serious and dramatic and impactful and important thing has happened that she's been at the center of all of it. And she has an opportunity now to make that mean something bigger. And that can be very healing, having that sort of transformative quality of an experience like this. You know, you had to endure it and it sucked and it was a challenge and you wish you hadn't had to, but you did. And because of that, you know, who do you want to be now? That's really what she has open to her. So just to see it as an opportunity, not as, you know, anything that she's required to do or obligated to do or anything like that, but just that, you know, she's got so much support, so many people that are willing to help her out and give her hands up, help her get back to where she needs to be. And frankly, Karen from day one has come across as a real fighter, like in everything that, like Mr. Alessi and Mr. Yanetti talked about her in that interview with Ian. She sounds like a pretty tough cookie. And so she does seem like somebody who has it in her to make this about something bigger than her and just what she has gone through. Make it more significant, make it more meaningful, make it something that is helpful and beneficial to others in the community. It's a real opportunity like that. So obviously put herself first and what she needs first. But if she does have the space to be able to do that, I think she could find something like that ultimately very rewarding.
Right, absolutely. And Valhalla Wade says, I hope she starts an anti-corruption campaign. I hope she runs
The
for
Karen Reed Foundation for anti-police corruption. Like who wouldn't support that? Like how can I get on the board? Like
I hope she I
love
hope she runs for Morrissey's position as a DA. I don't know. I don't know how it works there. Do you have to be a lawyer to be a DA?
Yes.
Oh,
Yes,
okay,
you do.
cool.
There are
I never
some
knew that.
jurisdictions where you do not have to be a lawyer to be a judge, to be like, I don't think at a high level, like Superior Court judge or something like that. I think most places you always have to be a lawyer for that. But there are some places where you can be like a municipal judge. You don't have to be a lawyer at all. I've seen like so many shit show cases of those courts and those jurisdictions. Yeah, don't recommend it, but it is theoretically possible. I don't know about in Massachusetts though.
Oh yeah, Cadna Williams, thank you so much for becoming a member of the Heinz Condemned Island. I appreciate that. I hope you enjoy your membership, and I thank everyone here for tuning in to this talk in regards to the verdict. I really appreciate Andrea for taking time out of your busy schedule to speak with me about this case. It's been epic because I've never seen such an high skill lawyering. Like, I mean, I can't even compare this to Deb V. Heard. I think they're really bad and Deb V. Heard. I haven't seen.
Oh, they're
I
much
mean,
better.
yeah,
Better.
like
I mean, Hines, as you know, the thing we were like never really able to say about Dep V. Heard is how mid the lawyering was. Like we weren't really like able to say that. But this was a much better case to watch from a legal skill standpoint.
I've never seen a lawyer graduate in 5 different majors in one case. Like Alessi.
Yes.
Alessi taking us on a dictionary tour. Like wow.
Yes. I will
cross-examining
never
so
forget
much.
pathognomonic. I'm gonna like use it in every other sentence now. I have no idea what it means, but I love the sound of it. It just rolls off the tongue. Pathognomonic.
I appreciate super chat here. I gotta read this. Equality. Thank you so much for your super chat. It says Heinz cooling camera cooling fund. Can we hear Andrea say I'll allow it? Guys, I'll start a GoFundMe for a camera that doesn't break just because the temperature is a bit. It is hot here. It's so hot here. I know you guys
That's what I've
look at it.
heard. Yeah.
Yeah,
That's what
I
I've
know.
heard.
Yeah, I know that you guys look at the temperatures and see 78 Fahrenheit and think, oh my gosh, how are they complaining over there? But believe me, I'm sweating like it's really bad.
It's an
really
impressive.
humid.
It's an
Yeah.
impressive heat. I do understand it. You got the humidity and like the air doesn't move at all, and there's like 5 people in London that have air conditioning, and the whole thing is
I don't have
unbearable. I
I
get it.
don't have AC in my house, so like it's
Oh
just
yeah.
like I sleep like I can't sleep. Like it's so hot. It's so hot here. But anyway,
It's the worst. It's
yeah.
the worst.
Kim Neighbor, thank you so much for your $19 super chat. I appreciate you. She says, great show. I appreciate you for even tuning in. I appreciate every single one of you tuning in. And thank you so much, Brandy, for your kind words saying that this was an awesome interview. You did a great job. I genuinely enjoy every second of it. I legit watch Andrea every day for the last 8 weeks. So of course I'm sweating. I appreciate that. I mean, Andrea is a great watch. I really admire how you kept your neck on Ian Griffith's girlfriend. I forgot the name of. I forgot her name. Alice. I don't know. But
Oh
Ian
yeah.
Griffith.
Well, crazy Alice Evans. She's
Yes.
she's been on a whole thing like the last couple months. I've been so busy. I haven't been able to follow up on that. But yeah, she's got a hearing coming up at the end of July. So I'll be keeping my eyes on that, of course.
Yeah, I look forward to that because that case, I'm like, you know, you don't get a whole lot of transparency in family court. So like, you know, just seeing your commentary on it is really good. So
yeah. Oh boy, you thought injustice in criminal court was bad. Let's take a visit to family court, shall we?
So many. I've heard so many cases where they just make up accusations and it's never scrutinized. It's just taken on face value. Nothing happens when there's counter evidence. It just goes away, and that's it. It's just I don't know. Like, but for her, she's really crazy. It's like she's really
she
crazy.
is. She's a nutter.
Yeah. Before we close off, I just want to say that Ian Whiffen did not even know, as an expert, the difference between certain degrees and Fahrenheit. He didn't even.
Oh yeah, that's true.
Was a funny highlight. That was funny. I mean, I know he's a Brit as well, but like, I was like, come on, bro, you're on trial. You should at least.
You're in an American courtroom talking to an American jury. You can't be bringing your metric Celsius stuff in here. What do you think we are? Educated.
Absolutely. I thought that was the moment. I was like, I could not believe it. Like, unless he just took his time with that one. It's like, oh. But
like,
what
do you even do with that?
Anyway, I hope you return for I know a stream one day. I hope we can do this again.
Definitely.
I will be watching for your next case coverage. I don't know when that when does
Coburger starts. Jury selection starts on July the 30th, and then the evidence is supposed to start on August 11th.
Okay.
So it's coming right up. It's just right around the corner. I'm already like how it's the end of June, and I'm looking. You know how it is. Trying to get that figured out.
Yeah, get your Franken truck going, like hit those mountains.
That's really I need like a Franken mower. I need some more automation over here on the old chore system.
All right. I'll leave it there. Thank you everyone for tuning in. I'll see you on the next live. Make sure you hit the like button as well as the subscribe button. Thank you all the mods that has been modding Random Girl and Valhalla Wait. I appreciate you. And I'll just bring this to a close. Andrea, once again, thank you for joining. And I'll see you guys on the next one. Bye for now. Thank you for tuning in for another episode of the Catch Up Court podcast. Don't forget to like this video, share this video, and subscribe for more legal cases that we cover on this channel. We do nothing but cover legal cases and true crime on here. You can also check out our playlist that we have of all of our content. They're all available in the playlist option. Make sure you go check that out. So make sure that you hurry back and catch up with us. See you on the next one. Bye for now.